Art Babbitt. Art Babbitt. Bob Harris. Devin Kelly.
Present.
Deborah Lewis.
Yes, present.
Diane Lorden.
Present.
James Maloney. Jed Westover.
Present.
Thank you. We have a quorum. Next item on the agenda is the approval of prior meeting minutes. This is the approval of the August 7th, 2024 and April 3rd, 2024 meeting minutes. May I have a motion?
I'll motion to approve the minutes.
Is there a second?
I second.
Any
approval.
discussion? Seeing none, all in favor say aye.
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 And all opposed
Aye.
say nay. The motion passes. Next item on the agenda is public comment. At this time, any member of the public may address the board on any subject within their jurisdiction that is not scheduled before the board on that day. Due to open meeting laws, the board cannot discuss or act on items presented during this portion of the agenda. To address the board on an item that is not on the agenda, please wait for the chair to call the public comment at the time the item is heard. There appears to be no public comment at this time. We'll move on to the next agenda item, which is the public hearing. And the first portion of the public hearing will be the staff presentation.
Do you want to just go ahead and read the case number?
Yes. The case number is PZ-24-00074, an appeal of the zoning code interpretation on marijuana establishment separation requirements.
All right, you can go ahead and start the timer. Thank you so much. Tiffany Antal, Zoning Code Manager. Today I am here to present on an appeal of a zoning code interpretation that was on marijuana establishment separations. So just overall appeal process and review, section 10208020 of the zoning code provides a process for appeals of interpretations by the zoning code administrator or planning director. I assist the planning director in their decision, in their role as that zoning code administrator. The Board of Adjustment shall review the application and the recommendation of the zoning code administrator, and following a public meeting, the Board of Adjustment shall reverse or modify the interpretation under appeal only upon finding an error in the application of the zoning code regulations on the part of the administrative officer rendering the interpretation. The Board of Adjustment shall grant the appeal subject to specified conditions, or deny the appeal. The purpose of this interpretation on April 17th, 2024, regarding the marijuana establishment minimum separation was intended to address when the minimum separation requirements for marijuana establishments are addressed in the development review process. The April 17th interpretation from the zoning code administrator identifies when the uses requiring separation are determined to be existing, i.e. at the time of certificate of occupancy, and when the city determines conformance with the separation requirements. So two separate issues. So right here are the code provisions. I've abbreviated what's in the staff summary and just pulled the relevant code sections here for your review. You can see that prior to the submittal of a building permit or business license, a concept plan is required for a new marijuana establishment. This is different from our standard concept plan requirements. For example, on a change of use, we don't always require a concept plan. And so a lot of times these uses can go in existing buildings. It is technically, while it's a marijuana establishment, it technically does fall under retail, same as a pharmacy. So in that regard, we didn't have the ability to require concept plans before, but the code is very clear now that regardless of those other standards for concept plan, that a concept plan is required for marijuana establishment. The concept plan application is required to include a scaled survey sealed by a land surveyor registered in the state of Arizona depicting the property lines of the lot or parcel that is proposed to contain the marijuana establishment and the separations from the nearest lot or parcel that contain any of the existing uses listed in subsection F. So let's talk about what subsection F has. Subsection F has minimum separations that need to be maintained for a marijuana establishment. The first is all marijuana establishments need to be separated by a minimum of 2,000 feet from residential substance abuse treatment facilities, 500 feet from a community college, university, or from any public or private school, 500 feet from a daycare home or daycare center, 500 feet from a public library or public park, and 500 feet from a facility devoted to family recreation or entertainment. In staff's review of the applicant's grounds for appeal, this is what staff understood to be their grounds. That first, the interpretation violates zoning uniformity requirements by treating the vesting of certain uses differently, conflicts with Arizona law on rights vesting, conflicts with previous interpretations, is contrary to state licensing requirements for marijuana establishments, and the interpretation is undesirable policy and that it is based on the identity of the user or business owner rather than the use itself. So here are staff's grounds for recommendation to keep the appeal or to deny the appeal. Pursuant to section 1040-6220B of the zoning code, the concept plan application for a marijuana establishment must include an affidavit that verifies the proposed marijuana establishment meets the separation requirements. The zoning code was amended in 2021 to add the requirement that every marijuana establishment submit a concept plan application. Staff's acceptance of the affidavit submitted with the concept plan application establishes conformance with the separation requirements and locks that determination in throughout the development process. It would be inefficient and potentially injurious to an applicant if the city were to require an affidavit establishing conformance with separation requirements at the time of concept plan application, but then wait to make a final determination of those separation requirements at the time of certificate of occupancy as suggested by the appellant. For example, an existing marijuana establishment recently relocated to a former restaurant and extensively renovated the structure to serve as a marijuana establishment. A timeline of their development review process is provided to show the length of time it can take to obtain certificate of occupancy. So from the first, in November 2020, applicant received a zoning verification letter for the property establishing whether or not a marijuana establishment was a permitted use. In December, the letter recommended a concept plan. However, a concept plan was not required at the time. The applicant was still willing to come forward and do the concept plan as requested. So a concept plan was submitted. The affidavit was submitted in conjunction with that concept plan. The concept plan was then found complete in February, and then building permits were submitted to the city in April of 2021. Building permits were issued in June of 2021, and certificate of occupancy was issued June 30th. So in that case, staff did not require an updated affidavit to establish conformance with separation requirements prior to the issuance of certificate of occupancy. If the city had not established conformance at concept plan application, the marijuana establishment in this example could have expanded significant time and resources to renovate their new location, only to be denied a C of O if a daycare had been established nearby. So you can see it's over a year time frame, and that is the restructuring of an existing site. That's not even new construction. So timing of conformance of decision, the purpose of the separation requirement is to ensure that marijuana establishments are not established near certain existing land uses. When a marijuana establishment applies for a concept plan, it becomes public record and allows other businesses or property owners the opportunity to determine their appropriate surroundings. Thus, establishing conformance with separation requirements at concept plan application supports the intended purpose of the regulations by providing notice to uses that seek to locate in the same general vicinity as the proposed marijuana establishment. The affidavit can only ever represent a moment in time, and it is possible that new uses that require separation will be established during the time it takes to establish a marijuana establishment. The time frame to establish a new marijuana establishment can vary based on many factors, such as whether it's new construction or alteration of an existing site. Consistent with other separation requirement reviews, the interpretation appears to be consistent with the Arizona Department of Health Services, when the Arizona Department of Health Services establishes conformance with the state's single separation requirement. The following are sections from the rules in the Arizona Administrative Code governing the state's medical marijuana program. So staff looked at this just in terms of reliance on when other entities might also consider the separation requirements, knowing that the Arizona Department of Health Services has a similar separation requirement. So a dispensary out of these administrative code, a dispensary or dispensary's cultivation site shall be located at least 500 feet from a private school or a public school that existed as applicable before the date the dispensary submitted the initial dispensary registration certificate application, before the date of an application to change the location, before the date of an application to add a cultivation site. Also, you can see that the health department shall deny an application for a dispensary registration certificate or renewal if for an application for a dispensary registration certificate, the physical address of the building, or if the applicable, the physical address of the dispensary's cultivation site is within 500 feet of a private school or public school that existed before the date of the dispensary submitted the initial dispensary registration certificate application. So you can see here, again, all of the befores. Conformance and vesting. The appellant argues that the subject interpretation treats the vesting of uses differently or non-uniformly, which conflates conformance with vesting. Vesting is a legal term that refers to when a right or interest in property is secured, which is not at issue here. The subject interpretation merely determined when conformance with the city's adopted separation requirements will be established. The appellant goes on to state that the subject interpretation conflicts with other staff interpretations. There are no official interpretations of the zoning code administrator that reference the time frame for reviewing and accepting an affidavit confirming the minimum separation requirements for specific land uses. I know that there are several emails within the documentations that you received of different questions that have been asked of staff. The answers that a staff person will give, again, are not necessarily an official interpretation, but a staff person can only respond to the question that is asked. And if a question is specifically asked, when is a use vested, you will receive in response when a use is vested, as opposed to asking the specific question of when is conformance with the separation required and met. So I would point out that none of the emails specifically referenced ever asked the question, when is the minimum separation and conformance determined? And lastly, policy considerations. The appellant is concerned that the subject interpretation represents undesirable policy in addition to concerns that the interpretation was influenced by the owner of the daycare rather than the daycare itself. Neither of these issues speak to an error of the zoning code administrator, as is required to overturn such an interpretation. The staff's recommendation is that the appellant has not identified a specific error of the zoning code administrator in the subject interpretation. So in accordance with the findings presented in the staff report, staff recommends that the Board of Adjustment uphold the subject interpretation and deny the appeal. If you should have any questions, I would be happy to try to answer those.
So one of the requirements was the survey, like the land survey showing that everything was in conformance. Was that provided? Do we have that? Is that there and available?
So for the most recent application, yes. An actual survey document it's a little bit different how we worked that through. And we definitely did this on both recent marijuana establishments. So having a survey completed of 500 feet was a little exorbitant. So we ended up doing something a little bit different. But yes, we have affidavits from that property owner at the time that they submitted their concept plan. Anything else? Seeing none, I will turn it over to the appellant for their presentation.
Good morning, Chairman Kelly and members of the board. My name is Heather Dukes, and I'm an attorney at 5527 North 25th Street in Phoenix. I'm here today on behalf of my client, the Woodlands Daycare, located within 500 feet of the proposed Nirvana dispensary. We are requesting that this board overturn the zoning administrator's April 17th interpretation and issue an order requiring Nirvana to obtain a variance approval of the 500-foot separation standard if they choose to move forward with this location. And before I get into the details of why this interpretation is erroneous and an abuse of discretion and arbitrary, among other things, I want to comment briefly on the email correspondence in this case. As part of my preparation for a Board of Adjustment hearing, typically, I submit a public records request to staff, asking for all correspondence and documentation that are in the file. And when I received the email correspondence from the city of Flagstaff, quite frankly, I was surprised. I was surprised at the maneuvering that took place in order for the city to ultimately reach a decision in favor of Karen Patel. And Mr. Patel is the owner of the proposed dispensary property and a known developer and property owner in the hospital sector in the city of Flagstaff. I was also surprised that the city maneuvered their way so that somehow the dispensary was the winner and the daycare was the loser. And not just any dispensary, a multi-state operator with locations in several states. The city chose to help that dispensary as opposed to the protected daycare use that is a small local business run by City of Flagstaff residents. And I think what surprised me most is that in the email correspondence between staff and with Nirvana, in early to mid-April, that email correspondence showed that the zoning administrator initially made the right decision. The zoning administrator informed the Nirvana dispensary and Mr. Patel that they would need to obtain a variance approval of the 500-foot separation standard from our daycare. And then approximately 1 week later, something changed, and the zoning administrator issued a completely different interpretation on April 17th. She determined that the dispensary no longer needed a variance, and she found that the dispensary separation standards would be determined and vested at the time of concept plan approval, or a concept plan review. There are significant errors in this interpretation. It provides special treatment to a dispensary to the detriment of a protected daycare use. The interpretation also violates several sections of the zoning code, and it conflicts with previous interpretations and correspondence issued by the city to not only other dispensaries, but also other uses with separation standards. Today, my presentation will focus on the daycare status as an existing use, how the interpretation directly conflicts with the zoning code, and some key items in the evidence before you that I think will help influence your decision in favor of our appeal. And if I could succeed in leaving you with 3 key takeaways, it would be these. First, the Woodlands Village Daycare is an existing use. The daycare submitted a building permit application first, and most importantly, the daycare was lawfully operating with a C of O and a business license before the dispensary submitted any formal applications to the city. Second, the concept plan review process is an informal process, and there's no binding approvals that are issued at that stage. In fact, no approvals are issued at all. The code makes this very clear. So there's no way that the Nirvana dispensary can be issued a binding approval regarding separation standards at that informal concept plan review stage. Third, the zoning administrator has no authority to modify the zoning code or its requirements. And the zoning code makes it clear that all uses are reviewed for compliance with the zoning code at 3 stages. At the stage of site plan review, building permit review, and certificate of occupancy review, and I'll show you those code sections. Nowhere does it say that you just go through concept plan review, they evaluate you for conformance with the zoning code, and that time is then cut off. You're not reviewed thereafter. The zoning code does not say that. So based on these 3 points, I'm asking you to make a decision that the zoning administrator erred in issuing the April 17th interpretation. The zoning administrator should have enforced the zoning code. That's her job, to enforce the zoning code, and followed through with her initial decision requiring the dispensary to obtain a variance approval. So I want to start first with the daycare use and provide some background and then get into how the daycare is an existing use and the 500-foot separation should apply. So the entity that opened the Woodlands Village Daycare Center is FLG Industries LLC. This entity was created by my client Ryan Hermansky and his wife Courtney. In talking with members of this community, their team determined that there is a shortage in daycares. They talked to people in education, in the education sector, their team members at work, and various members of this community. And what they did find out is not only is it hard for working families in Flagstaff to find daycare services, there's also a shortage of daycare businesses where Coconino County can send their students to earn their education credits for their teaching and childhood education programs. And I want to be transparent. Ryan Hermansky is part of the cannabis industry. But more importantly, there's a purpose behind creating these daycares. And it's rooted in his wife and also their long-term plans to open other daycares throughout the city of Flagstaff. Courtney Hermansky, his wife, has an undergraduate degree in literature with a master's in childhood education. And so this is part of her business plan, is to open these daycares. At this specific location, they allow for 5 kids at the daycare, and they could increase their numbers if they get additional licensing from the state. Right now, they have 3 children enrolled, ages 18, 2.5, and 3.5 years in age, and they're open Monday through Friday from 8 a.m. to 6 p.m. So again, the pictures demonstrate it's open and operating, and I'm gonna go through a few more slides to show you that it's existing. One of the things that staff really hit hard on in their staff report is that the daycare is not an existing use, and there's no definition in the zoning code that informs us as to when a use is existing. That is incorrect. The zoning code may not define existing use, but it certainly states when a use is established. Section 10-20-40-30 B as in boy, says no development shall be permitted or no new use established until the applicant has obtained a building permit and a certificate of occupancy. The zoning code does not state that a use is established at concept plan review. It says you have to have a building permit or a C of O. And in this case, the daycare has obtained both of those. The dispensary has obtained neither of those. And I'm going to show you on the city's own interactive planning map the history of approvals here. So on March 31st, 2024, the daycare obtained a building permit, they submitted their building permit application, and then on April 23rd, they obtained the building permit approval. Then on May 14th, 2024, the daycare was obtained their certificate of occupancy approval. On May 31st, they obtained the business license approval. Again, this is all for the daycare. If you click on the proposed dispensary parcel, it shows that the building permits for the Nirvana dispensary were submitted not until June 30th. We were already open and operating. So the one stage that this dispensary had to submit a formal application didn't occur until June 30th. We had already gotten our building permit and our C of O approval, and we're open and operating. So in terms of who's existing, it's the daycare. The daycare is existing, and the 500-foot separation standard should have applied to this dispensary. I now want to touch on my second point, and that's the fact that this concept plan review stage is an informal process. It says it in 3 different parts of the code. Section 10-20-30-50A, it says the concept plan review is an informal review. Section 10, 20, 30, 50, C3B, no formal action is taken by the director during the concept plan review. So this concept that they can give an approval of the separation standards at concept plan review and vest that approval at that time is completely against the code. The code also says in 10, 20, 30, 50, C3C, that's a mouthful, failure by the director or staff to identify all required studies or all applicable requirements shall not constitute a waiver of those studies or requirements. So it's putting the applicant on notice. You may go through our concept plan review stage, but it's so informal that there may be things that come up in the future that we may have to add to your requirements. And one of those things is separation standards. I want to go through a few statements in the staff report to demonstrate that the ZA interpretation is contrary not only to the zoning code, but also to other correspondence that they've issued to other uses that have separation standards. So in my letter to you, I talked about the zoning administrator's authority. The zoning administrator can only interpret and enforce the code. They have no authority to change it. And unfortunately, that's what this interpretation attempts to do. It attempts to change the requirements in the code. So when you look at the staff report, the city tries to gloss over several code requirements by telling you that the code doesn't address when separation requirements must be reviewed and determined. They say, with respect to the separation from existing uses, the zoning code does not clearly state when the required separation requirements are required to be reviewed and determined to conform to code. That is wrong. That is not accurate. The zoning code clearly states that uses are reviewed and determined to conform to the code at the three following stages: site plan, building permit, certificate of occupancy. So at the site plan stage, section 10, 20, 40, 140, C2A says, when considering an application for site plan review, the director shall consider the extent to which it complies with all requirements of the zoning code. All requirements means the separation standards. At the building permit stage, section 10, 20, 40, 30, B2 states, no building permit shall be issued unless the application complies with the provisions of the zoning code. The provisions of the zoning code includes the separation standards. And finally, at the certificate of occupancy stage, section 10, 20, 40, 30C says, no building or structure shall be occupied or used until the building official has issued a certificate of occupancy and has determined compliance with the provisions of this code. Again, provisions of this code includes the separation standards. And finally, section 10, 20, 40, 30C1 says, if the structure or use does not comply with the requirements of this zoning code, the director shall not issue a C of O. So if this dispensary does not comply with the 500-foot separation requirement at the time of C of O application, they cannot issue that C of O. The only way this dispensary can get a C of O is if they apply for a variance of the separation standard, and that variance is approved by this Board of Adjustment. That's the only way that can happen under the zoning code. The next statement in the staff report that was erroneous is it states, it would be inefficient and potential injurious to an applicant if the city were to require an affidavit establishing conformance with separation requirements at the time of concept plan application, but then wait to make a final determination to those separation requirements at the time of C of O, as suggested by the applicant. So the city can make the argument that somehow this dispensary is going to be prejudiced by waiting, but that's what the zoning code requires. It requires the city to wait to make a final determination on separation requirements until the time of the C of O. And that is typical for a lot of uses in the city. One of them is the adult use section. If you go to section 1040, 60, 50C, in C1 it talks about the separation standards that adult uses have to maintain. They have to maintain 500 feet and 750 feet from various uses. But then section C3 talks about when the separation standards are applied, when they're determined, when the adult use is determined to be in compliance. And I have it highlighted here. It says, an adult-oriented business lawfully operating in conformity with this section does not violate this section if another location-restricted use, so let's say it's a daycare, If a daycare subsequently locates within 750 feet of the existing and operating adult-oriented business. This section does not say within 700 feet of the concept plan review stage. So if this section requires the adult use be open and operating, and then the city determines whether they're in compliance of the separation standards. They're giving the dispensary in this case a double standard, a better standard. The adult use section specifically says that the adult use has to have a C of O, needs to be existing and operating, and then the city will evaluate the separation standard. So why in this case are they treating the dispensary different? I'm just going to touch on this briefly, but Cameron from Gamridge and Burnham is going to discuss this in greater detail. One of the big things that staff went through in their presentation to you this morning is that there was another example of another dispensary relocating in Flagstaff. And they took a very long time to go through the development review process, and they ended up amending the code to require concept plan review for dispensaries so that these dispensaries weren't prejudiced. And it says in this red section that's highlighted that in that case, this former dispensary, if the city had not established conformance at concept plan application, the marijuana establishment in this example would have expended significant time and resources to renovate their new location only to be denied a C of O. So in this case, they didn't determine conformance at concept plan review stage. That client actually asked the city to do that. They said, can you give us some assurance at this concept plan review stage that you will determine the separation standards at this time, and you'll cut off that review. It will be vested. We'll be able to move forward knowing that we comply with all separation standards at concept plan review. The city would not agree to that. Instead, the city said there's two options. You can either get site plan completeness and approval, or you can apply for a building permit. That's when we'll determine compliance with the separation code, or separation standards under the code. And that was an email from 2021. So Cameron will go over that, but I just want to flag that to your attention that that's an inaccurate recitation of what happened for that other dispensary. There's also two interpretation letters, and I have two more slides, and then I'm going to sit down. As part of the staff report, the city gave you two interpretation letters, two zoning verification letters. One's for another dispensary, one's for a custodial care facility. And the first letter is from 2020, it's to another dispensary, and it's a zoning verification letter. They're saying you have the right zoning, and here's the process that you need to follow. And so the city advises that dispensary, the property owner shall demonstrate that all requirements of the zoning code are complied with prior to obtaining a building permit. So they're saying to the applicant, we're going to determine compliance with the zoning ordinance at the time of building permit application. Not concept plan review, at the time of building permit application. And then they also warn the dispensary applicant, this letter does not hold the property as a medical marijuana dispensary location, nor does this letter prohibit another use from locating in the area. So what the city's basically telling this dispensary applicant is, this approval, this verification letter, the concept plan review you're about to go through, it doesn't hold your spot. Another daycare, another use, another school could come within the separation standard, and you're going to have to comply with the zoning code. And what that means is they would have to apply for a variance. So that's what the city's direction was in 2020 to another dispensary. It's completely opposite of what they're telling Nirvana today. The second letter with the custodial care facility is very similar. This is from as recent as November of 2022. And again, this is something that staff gave to you guys as part of their staff report. It talks about how custodial care facilities must be 1,320 feet away from one another. And it talks about how at that time, the custodial care facility was not within 1,320 feet of another facility at that time of this letter. And they say a conditional use permit would not be required so long as another facility is not located within that separation standard at the time of permitting. So they're not saying at concept plan review. Again, they're telling them at the time of permitting. And then they go even farther to say a change of use to this custodial care facility requires the review of a concept plan application. It requires you to provide a map. And so what staff just told you is that somehow dispensaries are different, right? They have to go through this concept plan review. They have to give an affidavit. They have to give a map. That's unique to them. No, it's not. They require the same thing of this custodial care facility. They're saying, go through concept plan review, give us a map showing that you meet the separation requirements, but we're still not gonna make that approval, that determination, until the time of permitting. So there's a lot of inconsistencies with this interpretation, and that's what we're asking the board to identify and determine that it's a bad interpretation. It's erroneous, not only based on the zoning code, but it's also contrary to communications that the city has given to other applicants, not only just dispensaries, but other applicants that have separation standards as well. So with that, I am going to sit down, but again, I would ask you to approve our appeal and overturn the ZA decision and require this dispensary to get a variance. Thank you.
Thank you very much. Are any board members have any questions?
So just wanted to clarify on those last two examples that you provided. So the dispensary, there was an issue with it back in 2020 with the concept, which then it seems like they amended their zoning code so that to avoid that in the future. So that example seems like it almost doesn't apply to this because they identified a problem back then and then they changed the code to address that. And then also on the adult daycare or whatever that was, that again, they amended the code so that a dispensary has to go through the concept plan. Maybe not everybody else, but they amended the code to make it so that a dispensary has to go through the concept plan. So with this being a different use, it seems like neither one of those two examples actually apply to this case.
Well, when you look at the amendment, the 2021 amendment to the zoning code where it requires a dispensary to go through concept plan review, they gave a list of application requirements. What the city council did not do is it did not say in that provision, that new text amendment, that the review of separation standards would occur at the time of concept plan review. That's nowhere in the language. So you can have a dispensary come in and make an application, and they'll give a survey map, they'll give an affidavit, they'll give all these various items, but that's just to get the application process going, because why would the city expend time and resources evaluating application if it's in violation of the separation standards from the get-go? That's when they tell the applicant, you gotta get a variance because you're within the separation requirement. So that's what the code says. These are all the application materials you need to submit, but what it does not say is that the separation standards are evaluated and finalized, determined at the time of concept plan. Instead, the code says in all those other sections that that determination is made at site plan, building permit, and C of O.
Okay, thank you.
I have a question. Can someone please confirm what the separation requirements are for a marijuana dispensary to a daycare?
The code says 500 feet, and it's measured from property line to property line.
Okay, so I'm looking at a map that was part of this procedure, and the daycare isn't even in that 500-foot zone. Is that correct? Am I looking at that map correctly?
It is within 500 feet. I'm going to show you an aerial here. So the property line of the dispensary is in red. The daycare facility property is in yellow. And so when you look at the separation from property line to property line, it's approximately 82 feet. There's also email correspondence from staff in the record where they talk, even if you were to measure it from the door of the dispensary to the daycare, it could possibly be within 500 feet as well.
I thought it was from building to building.
It's property line to property line. And
Thank
I
you.
think staff has a slide that they can pull up with the requirements. Oh, yes. Yes. And I just want to comment on one thing. The question earlier about whether the dispensary submitted a survey showing the separation standards. The survey that was submitted was measured from the dispensary building. It wasn't measured from property line to property line. So first off, it's inaccurate, and then it wasn't stamped by a survey, which is a requirement of concept plan review. It says the concept plan review application shall, and then it talks about a survey map stamped by a registered land surveyor. That map is not stamped by a registered land surveyor, and it doesn't measure the distances accurately. So from that standpoint, no, there's still no accurate map in the city's records.
I guess I'm still confused about why does the city think that these properties weren't within 500 feet of each other?
I think the city did know they were within 500 feet of each other, but there was some maneuvering as to which use was going to be deemed to be established first. And so at first they said in their email correspondence between each other, the daycare is first. They submitted their building permit application first. And then a week later, they came out with an interpretation saying that the daycare was not existing and the dispensary didn't need a variance. So that's the confusion for us.
Can someone from the city speak to this?
Someone from the city would be able to speak later.
Yes. How about, there's another chance to, for me to present, and so at that point in time, I can answer any questions you have.
Oh, okay, thank you.
Alrighty, are there any other parties for the appellant that are interested that would like to speak? Alrighty, next we have public testimony.
I believe there is an interested party online.
Oh, there is? Okay.
He's just an interested party, he's not for the appellant, I guess is probably the confusion.
Oh, apologies for that. Yeah, we'll have any other parties for the appellant, and then public testimony, and then a rebuttal, closing, and then concluding comments from
Just
staff.
any other interested parties. Okay.
Okay.
Good morning, ladies and gentlemen of the Board of Adjustment. My name is Jesse Callahan, and I'm an attorney appearing today on behalf of Nirvana Center. I am located at 1850 North Central Avenue in Phoenix. Can everybody hear me okay? I just want to make sure.
Yes.
Thank you. Also present today is Mr. Giovanni Dolleton. He's general counsel for Nirvana, and he's appearing remotely as well. Nirvana, so everybody knows a little bit of brief background about them. They're a national medical marijuana dispensary brand. They've been doing business in Arizona since 2013. And because of their adherence to state laws and professional operations, they've become a well-reputed business to the many customers and patients that they serve in numerous cities throughout our state. In this case, Nirvana worked hard to locate the proper site for it to begin operations in Flagstaff, one of the larger markets in Arizona. And after a lot of work, Nirvana identified the subject site and submitted for site concept approval, which, as we know, was approved. Now, unfortunately, what we have here is a competitor was monitoring the applications, and it's undisputed that it was after Nirvana submitted its site plan that this competitor, Noble Dispensary, through its principal, Ryan Hermansky, decided to interfere with the process. And they did so through this, what we believe to be a sham daycare. Now, the point of today's proceeding is about the sound determination by the city staff and its recommendation to uphold that determination. There's no doubt that the city's analysis is 100% correct, that the staff's recommendation should be followed, and that the anti-competitive misconduct that we're seeing from Nirvana's competitor, that should not be condoned or rewarded. But we don't need to delve into deciding whether the daycare is a legitimate business or was manufactured for anti-competitive purposes, because the appeal that the appellant filed, it lacks merit. The city staff's recommendation and analysis is spot on, and I'll briefly echo those points. First, the appeal is directed at a legal concept of vested rights. Again, there can be no debate. The zoning code interpretation by the city does not contain the words vested rights. That is a distinct legal doctrine that is irrelevant to the city's interpretation. It's the proverbial straw man argument, meaning the appellant is arguing about something the city never said and the city never did. And second, and similarly, the appellant's references to state licensing are not germane to this proceeding. Whether the state of Arizona ultimately approves the manufactured daycare or Nirvana's dispensary That is another issue for another day for the Department of Health Services to decide. Now, importantly, and really what we're talking about, and this is my last point, is that the public policy advocated by this appellant, it would be disastrous. The position taken by the appellant, if adopted, would deprive the citizens of Flagstaff of their right to fair competition, lower prices, and the substantial tax revenues associated with a fine and longstanding business like Nirvana. The appellant's request to rewrite the zoning code to suit its narrative to keep competitors away, rather than competing fairly and honestly, that's antithetical to the claim of public policy. And as the staff noted, it can take years to fully develop and open a dispensary. And it is not consistent with fundamental principles of zoning and due process to force a business to invest all of that time, money, and resources, hoping that a competitor will not attempt to rush a phony daycare in to stop them from moving forward. The position advocated by the appellant makes no sense, and the city's recommendation and Nirvana's position is completely logical and supported by basic principles of fairness. Now, the feigned concern expressed by the appellant, it's not genuine. That concern being, well, gosh, daycares aren't being protected. The protected use isn't in play. But any true daycare that doesn't want to be next to a dispensary can easily avoid those separation issues by virtue of choosing a location that did not have public notice of an approved site plan for a dispensary. In this instance, the sham daycare chose to come to this site despite knowing the process was underway when it could have chosen numerous other locations. So one has to ask themselves, why did this supposed daycare pick this location? And the answer is easy to see. They did so because of the site plan, knowing of the site plan to interfere with that process. The alleged protected use decided to come to where the development of this site was already underway. Those protected uses that are legitimate are all protected and remain protected because they would not want to open up next to a pending dispensary location, and they would choose a different spot. It's only the illegitimate shams that are not protected by this zoning interpretation. It's those supposed daycares who want to be next to a dispensary to interfere with its operations. They are not protected, nor should they be. The city's analysis here carefully balances and harmonizes the competing issues that are before the board today. And so we request that the appeal be denied and that the city's sound zoning interpretation be affirmed. And I'm happy to address any questions the board may have, and thank you for your time and consideration today.
Thank you. Are there any questions from any board members? Hearing none. Are there any other parties that have interest in the presentation?
There are none that we're aware of, so no, would be.
Alrighty, next up we have public comment. Is there anyone from the public who would like to make comments on the presentations?
Good morning, Mr. Chairman Kelly, members of the Board of Adjustment. We had a discussion with Ms. Antal before the hearing. There were a number of speakers that signed cards and wanted to sort of cede their time to me, and there was some discussion of maybe me getting 10 or 15 minutes to talk. I don't know if that's at the discretion of the chair or if that's traditional, but I would like that opportunity because the history of my client's application is sort of runs through this entire application.
I apologize, your name wasn't on the list,
Oh.
so I didn't realize, I
Oh,
thought
oh,
you
I'm
were
sorry.
speaking independently of the
Yeah.
group. So yes, I apologize. Can we give this gentleman 15 minutes?
No, I appreciate that. My name, Mr. Chairman, is Cameron Artigue. I'm a lawyer at Gamage and Burnham in Phoenix. I'm here on behalf of RCH Wellness, which operates a dispensary on Aspen known as Noble Herb. We are here as a member of the public to make public comment, But actually, the process that my client went through to open our dispensary in 2020, 2021, 2022, it's been referenced by every speaker so far this morning. It's referenced in the staff report in this matter. So it's kind of like bundled in with everything that's going on. First, let me say I have, and everyone at my firm has great respect for the entire staff at the City of Flagstaff. We work with them regularly. We think they do great work. We think, you know, they're very good at what they do. On occasion, mistakes are made. And that's why we have you as an appellate body to make sure that interpretations or other appealable actions don't come out of the city that are arbitrary and capricious. And this is our last stop, so we don't have to go to Superior Court and you know, talk about stuff there. So I'm gonna explain today why this interpretation should be overturned at this level. As I've gotten older, I like to simplify things more and more. I tell this to my kids, I tell this to younger lawyers, that try and cut out the jargon and make stuff easier to understand. And I'm gonna try and do that for you all right now. Okay, so we have a dispensary and we have a daycare. In general, we have a separation requirement to protect the daycare from the dispensary. The dispensary is kind of the risky use, and I put that in scare quotes because my client's a dispensary, but that's the sentiment behind the code, is that we need to protect daycares from dispensaries. So the daycare is the special favorite here. That's the use we're trying to protect. So how does it work in the ordinary course? If somebody has got a dispensary up and running like my clients, and a new daycare wants to locate 100 feet away, that's not a problem for the dispensary. That's the daycare's choice. And that's fine. That's the way it works. On the other hand, if there's an existing daycare in operation, like Ms. Dukes' clients, and the dispensary says, hey, that looks like a good location, they have to meet the separation requirement. It's 500 feet. Here it's 82 feet from property line to property line. So the dispensary says, hey, I guess there's a daycare there, or a school, or a park, or a sober home, all those protected uses. Now, the wrinkle here is that you have a dispensary that's in the early notional processes. It's not open. It's not anywhere close to open. So what are we going to do about that? And here I struggle for a word. My kids called it dibsing. When you take an action to sort of make sure that you put you stake your claim, you plant your flag. You've done something to assure that your right or your claim is protected. Now, once I went to law school, we started saying vest your rights. And lawyers like to say vesting your rights and vesting your use. It's the same idea. You can call it dibsing, you can call it planting the flag, you can call it securing your rights, but the question is the same. What does the dispensary have to do, or the planned dispensary, in order to not worry about a potential daycare anymore? The answer in this interpretation is that the dispensary just has to file a concept plan, which costs $420, and that's all you have to do. You file the concept plan. Now, maybe on a clean slate that would make sense. It's not what the code says. The code says a concept plan is not a formal process, and that the director makes no determinations at the concept plan. But we'll talk about that later. Let's just say that the concept plan vests your rights. On a clean slate, maybe that makes sense. But now, let's look at my client's experience, okay? So it's November 2020. This is back during COVID. My client wants to put his dispensary on Aspen Avenue. This is tab A to the staff report. Doug Daly, who's a lawyer, writes the City of Flagstaff and says, what are the rules? We're worried about a daycare or another dispensary, another use coming in and knocking us out. And the city responds with a zoning verification letter. And the city says, this letter does not hold your location, doesn't dibs, doesn't vest your rights, doesn't plant your flag, nor does this letter prohibit another use from locating in the area that would cause the property not to comply with the separation requirements. So the advice from the city is, hey, even though you're planning to locate here, you're at risk. If some other dispensary shows up or some daycare shows up, that's your problem. We provide no assurance to that. So what does my client do? They go do a concept plan, which was not required at the time and was subsequently required in the 2021 text amendment that member Westover asked a question about. That text amendment just requires the concept plan to be done. It doesn't say that it vests any rights or plants your flag, or it still doesn't have any legal effect and the director doesn't take any formal action, but it just requires a dispensary as in the category of uses that have to go through concept plan review. So, okay, so now my client's done the concept plan. It's March 2021, and these are the emails that Ms. Dukes showed you, and they're attached as tab A to the appeal letter that my office submitted. Doug Daly emails Genevieve Perthree at the city, and he says, now we've got our concept plan done, we're seeking some assurance from the city that the concept plan process will secure the property as it relates to the setback requirements. Setback requirements? Is there a setback issue? No. What he's talking about is separation. He's not talking about, building setback. Because the next sentence is, for example, should another dispensary submit for building plans within 500 feet, RCH would still be permitted to move forward. So the question being asked of staff is, does our concept plan protect us? Have we planted our flag, vested our rights, dropped our anchor? And Ms. Perthree writes back on February 10th and says, I'm discussing this with staff, including the city attorney. I'll be in touch with you next week. And then 4 days later, Ms. Perthree writes back and says, no, you're not protected. Concept plan doesn't do you any good. Concept plan is not a formal approval, and thus it does not vest a project in the current city code. Now, why does she choose that locution, vest it in the current city code? I don't know, but it's obvious what she meant. She meant the concept plan doesn't protect you, because her email closes and says there's two options for you. First, you can get site plan approval, but you're not subject to site plan approval. Second, you could get a building permit. So that's what you need to do to vest your rights. That's the risk my client faced, okay, in 2020 and 2021. So now you go to the staff report that is submitted to you just a week ago in this matter. And what it says on page 4, it recounts the timeline that I just went through for my client's project, and it says, if the city had not established conformance at concept plan application, comma, the marijuana establishment in this example could have expended significant time and resources to renovate their new location, which leaves you believing that the city determined conformance at concept plan. And they didn't. They did just the opposite. And so the upshot of this staff report is it doesn't show that the city's being consistent. It shows that the city has flipped, that things changed. Okay, so now I got 5 minutes left. Now, that was my wind-up. This is my pitch, okay? The city's interpretation is invalid for two legal reasons. One is it's arbitrary and capricious. You've heard that. If you're a lawyer or you're married to a lawyer or have a friend who's a lawyer, they talk all the time about arbitrary and capricious. What is caprice? Caprice means a change that doesn't have a good reason. Caprice is, just kind of flip-flopping for no rational reason. This is caprice. When you say, yeah, for the first dispensary to show up, concept plan didn't count for anything, and the next dispensary who shows up, concept plan drops their anchor, vests their rights, plants their flag, that's capricious. That's the kind of thing that is legally to be avoided. So we wind up with this strange situation where we're protecting the dispensary that doesn't exist yet as against a daycare that does exist. Well, that's backwards. The whole code here is supposed to be protecting the daycare. The second problem is the city is picking winners and losers and saying, oh, well, Noble Herb wasn't protected by their concept plan, but Nirvana is. Well, how does that work? You can't have a game where, where if one basketball team shoots a basket, it's worth 2 points, and if the other team shoots a basket, it's worth 4 points. That's not right. That's not fair. So that is what makes this arbitrary and capricious, and it makes it a mistake that should be corrected. The second problem here, and it hasn't been touched on yet, is that this interpretation tries to legislate. Mr. Finsel may have told you in an executive session at some point that or you may have heard, this Board of Adjustment has no legislative authority. You're a quasi-judicial body. That means if we want to add something to the code, it has to be a text amendment that goes up through council and gets approved by council through that process. This body has no authority to say, here's a good idea that would make sense. Let's just say that concept plan vests all the compliance with all the separation requirements. Whether that's a good policy or a bad policy is not for this body to decide. And what this code says is that concept plan doesn't result in any formal action, that the director doesn't take any formal action at the concept plan stage. So to say, well, actually, there is a formal determination that's made, that's legislating. The other thing that the existing code says is that an applicant needs to demonstrate compliance with all zoning code requirements to get a building permit. And all zoning code requirements includes separation requirements. So when you go in for a building permit, they check, are there daycares? Are there sober homes? Is there a city library within 500 feet? And again, at certificate of occupancy. And that's the advice that my client was given by the city in March of 2021. Now, if the city wants to change its code going forward, that's a great idea. We can have that discussion at Planning Commission and Council. But for today, this body's role is to ensure that the city makes consistent, logical, legal interpretations, and therefore I urge you to set aside this interpretation. Unless there are questions, I'm going to sit down.
Thank you very much. Are there any questions from any board members?
Thank you.
Thank you very much. Do we have any rebuttals from the appellant? Oh, are there any other members of the public for public comment?
And you're not listed on the 10?
Hello, my name is Ryan Haynes. I've been a resident in Flagstaff for approximately 8 years now. I have a completely different issue with the dispensary opening. I am in support of the appeal, just based off of a traffic issue that we have in this town. In the past 8 years, I've seen it grow, some for the better, some for the worst. University has grown quite a bit. We have a lot more traffic. I speak with residents of University Heights all the time. It's a large neighborhood. And we try to avoid Milton Road at all costs. Even before the construction, it gets locked up all of the time. We use Woodlands to kind of get around that traffic problem. And I've seen what dispensary traffic does to different intersections and different streets. And I feel that this would be a burden on anyone that lives in University Heights, Forest Highlands, Ponderosa Trails, just trying to get from point A to point B without going down the main road, Milton. It's just, in my opinion, with the Walmart being there, the hotels, adding a dispensary with the traffic that they see would cause undue burden on the residents of Forest Highlands, University Heights, Ponderosa Trails, anyone on that side of town. Again, it has nothing to do with these discussions, but I thought it should be heard. Thank you for your time.
Thank you very much. Are there any other public comments?
Good morning. So my name is Doug Daly from the Daly Law Firm. I was the attorney in 2020 that represented RCH Wellness during its relocation application, the timeline of which has been mentioned by many people here. My client, my former client, RCH Wellness, has a single retail dispensary. It's locally owned. The owner lives here in Flagstaff. And frankly, I was surprised and confused a little bit when I read the staff reports, with the implication being that concept plan was always supposed to vest the rights, because as we've now heard, that's the exact opposite of what we were told. So I had many discussions with staff, both in person and in writing, my emails of which are attached to our RCA's application, asking the very question addressed in the zoning interpretation. And that is, when do minimum separation requirements conform? When is that determined? The staff knew my question. There was everybody knew what the question was being asked. And we were told in no uncertain terms, after they said, hey, let's go back, we need to talk to the city attorney and we'll get back to you. They said that it's unequivocal that concept plan is an informal review that does not vest anything. You have to get your C of O, file for a building permit. Those were the two options that we were given, which is the exact opposite of what the zoning interpretation says. So this was a same use, same situation, different result. So why the inconsistency? We filed the concept plan, so they didn't amend something and change something in the future. We did what the code is laid out, the version of it is now. So in this case, what I can see is we have a large corporation, has, according to its website, 30 locations across the country, appears to have connections with staff, and the city seems to be bending over backwards to accommodate them. Why are we doing this? Where's the consistency? This, to me, is just not a procedural issue. It's really about fairness. If you're going to be bending over rules for large corporations, I think that sends a troubling message to local small businesses that they have to jump through all the hoops. But if you're a big player, if you're a Walmart, you're a Starbucks, we'll figure it out. So I think we have to ask ourselves, what kind of community do you want to build? What message do you want to send? One where we're helping out local small businesses, or one where we're going to bend the rules if you're a big out-of-state company? So to me, allowing this interpretation would set a dangerous precedent, lead to inconsistent application of the law where small businesses are held to one standard and large corporations are held to another. And for those reasons, I would respectfully ask the board to stand with local businesses and approve and grant the appeal. Thank you.
Thank you very much. Are there any other public comments that would like to be made at this time? Seeing none, we'll move on to the rebuttal, if there is any, from the appellant.
Thank you, Chairman and members of the board. I do want to just touch on two items. Okay, so the first item is whether we should even be talking about the state licensing requirement. Nirvana's counsel raised the issue of how state licensing is not germane to this issue. And there's a reason that he's saying that. First, I want to contradict what he's saying, because in the actual zoning interpretation dated April 17th, the interpretation determination on page 2, the very last sentence says, "The timing of determination of minimum separation shall be consistent with state licensing for similar facilities which occurs at the time of application as described above." So the city, in their interpretation, has actually referred to the state licensing requirements. So now I want to flesh those out with you. When a dispensary goes in for a approval to establish. They start at the city. It's not like the city and the ADHS process run simultaneously. They start at the city. They get their concept plan review, they get their building permit, they get their C of O. They're good. So they've made the improvements to the dispensary, it's ready to go, it's got its C of O. Then they go to the state licensing department. They go to ADHS and they submit for their approval to operate at that location. And one of the application requirements to the state is that you submit a copy of your C of O. So the point in time that the state agency is making the determination of separation standards is after the C of O is already issued. So this interpretation is not consistent with state law. It's not consistent with the state licensing requirements and when they make the determination on separation standards. So that is a very key aspect of this. The second item that I want to touch on is, again, what Cameron mentioned, what Doug Daly mentioned, is the inconsistencies with the zoning code and then also prior communications with dispensaries and other types of uses that have separation standards. But I want to touch on the inconsistencies that happened in just a week's time with regard to this interpretation. I'm going to go to slide 24. So this is Exhibit 3 to the appellant's letter. It's dated April 9th, 2024. And in this letter, Wesley is notifying the planning director. I just want to bring to your attention an issue that's popped up. And this goes to, again, what Cameron was talking about, who's planted their flag first. He says Nirvana Center is the dispensary we currently have in concept plan review. But we also received a building permit for a daycare in the shopping center across the way. Talking to Tiffany and Christina, a determination was made that a property owner is vested once their building permit application is deemed administratively complete. So they're talking about how, because the daycare has their building permit in, they're vested, they're the first in time. They get to fly their flag. And he says this will now make the site for the dispensary not suitable as a location due to the daycare building permit. So then the next email correspondence happens at Exhibit 5, where Daniel Folk, the director, emails Michelle, the planning director, and the economic director. And he says, assuming from Wesley's email that the daycare permit was found complete or issued, while the dispensary is still in concept plan review, no building permit submitted yet. So he's making sure this dispensary doesn't have a building permit. And then he says, for Heidi, this is why the daycare would be considered established or vested before the dispensary. So he's doing exactly what the code tells him to do. It is established because they got their building permit application in. The next, this is a continuation of Exhibit 5. And so the planning director responds and says, yes, the dispensary is still in for concept review and the nursery daycare has submitted building permits. So yes, that is why this is an issue for the dispensary. And then Michelle says, I've looped in Sean because the mayor has already received a call. And in prior communications, that's Mr. Patel calling the mayor. So as you can see from that correspondence, staff, the directors of each department are talking internally saying, hey, we've got a problem here because the daycare is now first in time. And in fact, this was communicated to both the dispensary, Nirvana, and the property owner, Mr. Patel, on April 12th. They had a meeting. The planning director confirms it. She says, thanks again for the discussion this morning. I wanted to follow up on the variance question. The 500-foot parcel line to parcel line separation from a dispensary to a daycare is a city zoning code requirement. Therefore, you could apply for a variance. So she's telling them, you could apply for a variance to meet our code. And then she says, when we complete the concept review, we will condition to make clear that a variance will need to be approved, or otherwise the determination of the daycare being an existing use be reversed. And I have it underlined in blue, the be reversed part, because that demonstrates that the city had already made the decision that the daycare was first in time, that it was an existing use. And this is April 12th. So 5 days yet later, we get an interpretation from the director that's posted online that says the complete opposite. So what happened in that time period? I don't know. I mean, at this point, it would be speculation. But All we know is from this correspondence produced by the city of Flagstaff, major inconsistencies occurred in a week's time frame. And we're asking you as the Board of Adjustment to enforce the zoning code and correct this interpretation, issue the correct interpretation. And that's this dispensary, Nirvana, needs to apply for a variance of the separation standards in order to proceed at this location, just like any other use in the city would be required to do so. If you have any questions, I'd be happy to answer them at this time.
Thank you. Are there any questions from any board members? Okay, hearing none. Is there a rebuttal from Nirvana's representation?
Yes, thank you. I will briefly, I'm happy to briefly touch on those 2 points.
Actually, they
that-
don't have a rebuttal.
Oh, they
Sorry.
don't?
No.
Okay, my apologies.
No, no worries. I had a couple good points, but I think they've already been made, so it's not necessary. Thank you.
And Tiffany, would it be typical to go into a closing testimony or just go back to staff comments?
Staff. Yep. I get to, I mean, I'm not as fancy as everybody else here, but, yes.
Okay, the testimony is now closed.
Thank you so much. So I did want to clarify on the question that Board Member Lorden had earlier. So the appeal is not about whether the daycare is located within 500 feet. The appeal, the interpretation addressed 2 issues. It addressed when conformance with separation standards are met or are accepted by staff, and then it is when is a use considered existing. So we're not in argument about when the use is considered existing. There's not a dispute between the appellant and staff. When the daycare received its certificate of occupancy, it became established as that existing use. So at the time that interpretation was written, the daycare had not yet received its certificate of occupancy, and that is why that topic was included in the interpretation, just to make very clear that an existing use was a use in basically that received its certificate of occupancy. The second issue is about the conformance with separation standards. So in regards to both of the zoning verification letters, they both reference us to looking at those separation requirements at concept plan. So the zoning verification letter for the first medical marijuana dispensary or marijuana dispensary establishment is prior to a code amendment. So it recommends a concept plan and it recommends submitting all of that data at concept plan, but again, we couldn't require it. The struggle that we had previously prior to requiring a concept plan was we had a marijuana establishment come in. They did not want to go through the concept plan requirement and per code could not require it. They came in for a building permit and we had to try to do that work through the building permit. Building permits are not retained and are not required to be retained under state law the same way that a planning file is required to be retained. So we had no way to retain that record. So we keep building permits until the building is finalized. And once that building is finalized, those records are released and gone. We don't keep them. We don't even track what comments or conditions were placed on building permits. That is one of the primary reasons why we changed the code to specifically require the concept plan. We absolutely had the ability in code. So it is clear from all of this discussion that the code leaves a slight absence on the actual conformance with these particular standards. what leads staff to making the determination that it is at concept plan is because that is specifically when that affidavit is required. That was not in place when Noble Herb went through their particular review, so staff could not rely on that piece of code at that time and could not make that interpretation at that time. In regards to a lot of the emails that have been presented and the various conversations back and forth, whenever a problem is vetted to staff, we operate as a team. Not one of us makes a decision in a vacuum. We work together. Often it is just common to vet a problem internally and discuss things internally before you go through the process of making a formal interpretation. And it's often, I mean, when you look at those emails, it's easy to take things out of context of an entire conversation. It looks like something suspicious is happening, that staff reversed roles or reversed our decision. It is something actually more innocent. I can remember the day Wesley walked into my office. I'm on my treadmill doing my little thing, and you have some basic conversations like, hey, what's your idea or what's your thought on this? As you sit down and you work through the problem, you can come to different conclusions. It's just where I would tell you that staff went on that. With that, again, I would just state that the reason why concept plan fulfills the need is to put any use that requires the separation on notice. At concept plan, that is public record. This daycare, for example, was very aware that there was a marijuana dispensary proposed within their vicinity. They absolutely did know that. The record shows that. So what we are telling you is the right reason. It meets that purpose. The concept plan provides notice to those uses that may choose to locate within the vicinity of that use. Daycares could choose to locate in the vicinity of also, a vape store or a bar or one of those things. That is their choice. They get to determine what's around them. There is that public record. They get to determine their environment. In this particular case, that's where staff landed, is that the public record is there for a potential new use to come in and find out what's proposed in their vicinity. And with that, I will finish, and thank you so much for your time.
Am I allowed to ask a question now?
Yeah. Any questions?
When did the daycare receive its certificate of occupancy?
What was the date? May 15th.
Thank you, that's all I had.
Okay, thank you.
Thank
This
you
is
very
Bob
much.
Harris. I have a question.
Yeah, go ahead, Bob.
Sorry.
Yeah, this question is for Tiffany. Some of the discrepancies that have been noted by council and others, are those primarily objected to because of the zoning language change in 2021?
I think the change in 2021 confuses the issue because of how one dispensary was treated over another, because they did fall at different timeframes in the code. So the interpretation, it's just important to recognize that interpretation, this interpretation occurred after a code change to require the separation affidavit to be provided to staff at the time of concept plan. And that was not previously a provision in code at the time that the other dispensary was located. So I think that does sort of confuse and cause distress and the concern that we're treating two dispensaries differently. Does that help, Bob?
Absolutely. I just wanted to clarify that.
I will wait before I say it.
Are there any other questions from any board members? Already hearing none. Thank you, Tiffany. At this time, the board can discuss what has been said during the public hearing. If board members have any points or questions that they would like to bring up at this time.
Is it too soon to propose a nomination for the denial of the appeal?
Next, we will go to a motion after any discussion, if any
Okay.
board members have any things that they would like to discuss about what they heard. But
No, I think it makes sense. There's a lot of stuff going around back and forth, but I think I have a solid understanding of everything now, so I think I'm good.
Okay,
I'm good as well.
I'm hearing no other board members or any further discussion. We can move to a motion. May I have a motion?
I motion to deny the appeal.
Is there a second?
I second the motion.
All opposed, say aye. Or sorry, all in favor, say aye.
Aye.
I think you actually
Aye.
need a roll,
Aye.
sorry, you need a roll call vote.
Okay, we'll do a roll call vote. Okay.
Bob Harris,
Yes.
Devin Kelly,
Yes.
Deborah Lewis,
Motion to deny.
Board member, you're voting on a motion to deny the appeal, so you need to vote yea or nay on that motion.
Yay.
Diane Lorden,
Yay.
Jed Westover.
Yay.
The motion passes. The next item on the agenda is informational items to and from board members and staff and future agenda item requests.
Thank you so much. At this time, we don't have any future item requests. I do miss seeing you all, but it was great to see you this month in August, and so I'll be in touch if something should come up in the future.
Alrighty,
Thank you all so much for your time today. We really appreciate it.
thank you very much. I declare the meeting adjourned.
Thank you, everyone. Bye.
Yes, I need him to sign the minutes.